International humanitarian law, often referred to as the law of armed conflict, is a body of public international law designed to limit the effects of armed conflict for humanitarian reasons. At its core are the 4 Geneva Conventions of 1949 and their additional protocols, which establish universally accepted standards for the treatment of individuals in times of war. This framework aims to strike a balance between military necessity and humanitarian considerations, protecting those not participating in hostilities and restricting the means and methods of warfare. The origins of international humanitarian law can be traced back to the mid-19th century, notably to the Battle of Solferino in 1859, which deeply affected Henry Dunant, the founder of the International Committee of the Red Cross, ICRC. His experiences led to the First Geneva Convention in 1864, focusing on the care of wounded soldiers on the battlefield. This initial step evolved significantly, culminating in the comprehensive 1949 conventions, adopted in the aftermath of World War II, to address the widespread suffering witnessed during the conflict. International humanitarian law operates on several fundamental principles. The principle of distinction mandates that parties to a conflict must distinguish between combatants and civilians, and between military objectives and civilian objects, directing attacks only against the former. Proportionality prohibits attacks that may be expected to cause incidental loss of civilian life, injury to civilians, damage to civilian objects, or a combination thereof which would be excessive in relation to the concrete and direct military advantage anticipated. The principle of humanity underpins the entire framework, prohibiting unnecessary suffering and ensuring humane treatment for all individuals. The 4 Geneva Conventions of 1949 specifically address different categories of protected persons. First Geneva Convention protects wounded and sick armed forces in the field. Second Geneva Convention protects wounded, sick and shipwrecked members of armed forces at sea. Third Geneva Convention concerns the treatment of prisoners of war, POWs. Fourth Geneva Convention provides protection for civilians in times of war, including those in occupied territories. These conventions have been supplemented by 3 additional protocols. The first protocol, 1977, strengthens protection for victims of international armed conflicts, including defining combatants and civilians more clearly. Protocol 2, 1977, extends international humanitarian law to non-international armed conflicts, civil wars, which were not extensively covered by the original conventions. Protocol 3, 2005, established an additional distinctive emblem, the red crystal, alongside the Red Cross and Red Crescent. Despite their universal ratification, the implementation of the Geneva Conventions and their protocols faces significant challenges. Violations, including attacks on civilians, torture, and the destruction of civilian infrastructure, continue to occur in conflicts worldwide. Enforcement mechanisms rely heavily on state responsibility, national legislation, and the role of international bodies like the International Criminal Court, ICC, for prosecuting war crimes. However, political will and accountability remain critical hurdles. In conclusion, the Geneva Conventions and international humanitarian law represent a crucial effort by the international community to mitigate the brutality of armed conflict. By setting clear rules for the conduct of hostilities and the protection of vulnerable populations, they serve as a vital framework for upholding human dignity, even in the most extreme circumstances. While their effectiveness is constantly tested by evolving conflict dynamics, their foundational principles remain indispensable for fostering a more humane approach to warfare.